Okay, my colleague Herb Hovenkamp is going to moderate this session. I'll pass over the wireless mic.
Thank you very much. Okay, hi. I'm Herb Hovenkamp. I teach here at the law school and at Wharton, mainly in antitrust. And I'm delighted to bring this group of people today. We've got Professor Aviv Nevo, the second person for me in the panel. He's the Jerry A. Weiss and Lydia Bravo Weiss University Pick Professor who teaches economics at the Wharton School, former Chief Economist of the Antitrust Division. And then just beyond him is Willard Tom, who's a partner at Morgan, Lewis, and Bockius. He was former General Counsel of the Federal Trade Commission, former Deputy Director of the Bureau of Competition at the FTC, and very heavily involved in the drafting of the IP licensing guidelines, which are jointly issued by the Department of Justice and the Federal Trade Commission. And then at the far end is Henry Wixon, the Chief Economist of Nist, the National Institute for Standards and Technology, which is part of the United States Department of Commerce. And then finally at this end, Kirti Gupta, who is Senior Director of Economic Strategy at Qualcomm. Now this panel is going to range a little bit beyond Motorola versus Microsoft and talk about a number of things. Part of it is the future of standard setting. Part of it will be the role of government agencies in standards setting, speaking particularly of Nist and also the Antitrust Division of the Justice Department. We may get a little bit into antitrust, both the question of whether, and if so, which particular practices ought to be addressed under the antitrust laws. So with that, I'm going to turn it over to Aviv.
Thank you. So I didn't prepare slides, partly because I wanted the flexibility to change what I have to say kind of on the go, and partly because I'm lazy. But let's go with the first reason. So the title of this session, I believe, is Emerging Legal and Business Issues in Standard and Essential Patents. So I'm not a lawyer. I don't play one on TV either. My last business endeavor was when I was 9 years old, and Herb, you'd like this, had a vast cucumber selling business in Kalamazoo, Michigan.
Oh my gosh.
Herb and I discovered a common background in Michigan.
Kalamazoo
in our background. So I guess I'm not a lawyer, not a business person, I'm done, you know, if we're talking about business and or legal and business issues. Emerging, yeah, maybe. I don't think it's the emerging lawyer or the emerging business person in me. I am an economist, however, so let me add economics to the title and say economic, legal, business, and economic issues in standard and essential patents. So what are the economic issues that we'd like to talk about? Well, there's several that I can talk about. None of them having to do with criticizing Judge Robart. So I'm not going to be one of those economists that have anything to criticize. Actually, quite the opposite. I think I agree with many of the points that that you've made earlier in your speech. So what am I going to talk about? I'm going to try to talk about two issues. Probably going to run out of time, so I'm going to briefly talk about the second one. So the first is really the role of antitrust agencies in standard and essential patents. How much should they be involved, if at all? Have they done good or not? Kind of that role of issues. I'll talk about that. And then second, I'll talk a little bit about something that was touched upon by the first panel, which is really what's the royalty base or what's the right level at which to apply royalties. And I'll touch about it a little bit. It was discussed somewhat. I'll just kind of briefly touch on some of the economic issues and kind of throw them out there, and probably most of them are going to be left out later for discussion if anyone bites in. So let me start kind of about the role of government. So let me go back, I think, kind of to my undergraduate days, where I was actually taught that antitrust and intellectual property are kind of, they're in conflict, right? One is about granting monopoly rights, and the other is about protecting competition, so fighting against monopoly. And there's a certain sense in which this is right, but it's really in some sense too simplistic. Okay, both IP policy and antitrust policy are really about preserving competition, preserving the incentives for innovation, which is really what, in some sense, competition policy is about. So they're really, even though they might seem as to be going against each other, and sometimes they do, they really ultimately are about the same thing, which is really trying to assure competition, that the market works and generates benefits ultimately to consumers. So again, while there are conflicts, they really do share a lot of the same goals. And this is especially true, I would say, in the modern economy because of two things. One is innovation is key. That's what's really driving growth in the long run. And that's what we have to remember. It's not about, short term, do you have this, do you have that? It's really about the innovation. If we take innovation away, we're not going to see growth. Maybe not immediately, but ultimately, that's the driving engine. So that's one. The other is the fact that coordination was always beneficial, but extremely beneficial now. Okay, think of what our cell phones would be if basically, Apple would have one standard, Samsung would have another. Who knows how many other standards would be out there, right? I mean, think back to the, videotapes, right? The Beta, the VHS. I mean, the world. I mean, eventually that got sorted out, but you could imagine, the world would be in a much worse place, and we wouldn't have, 4G talking about 5G, Internet of Things, and all these things that are coming, unless we had a common standard and a common way to get data, not just here, but right, I can, use my phone here, I can use it at home, I can use it when I go to San Francisco, but I can also use it when I go to London or to Seoul, right? It's having that, and that only really comes through coordination, and that's a huge benefit, and we have to kind of remember that. So the second reason is, is particularly important as to why why having setting in organizations or standard developing organizations is very important. We have to keep that in mind, and we have to keep in mind that we really want to encourage these activities. On the other hand, this is from the antitrust point of view, these are competitors getting together in a room and talking. And to the extent that we think of what's kind of the cardinal sin of antitrust, it is about competitors. Usually we talk about smoky rooms. These don't have to be smoky rooms, but getting together and talking. Okay, so very careful. There's enough lawyers in the room to make sure you're not discussing prices, but at the same time, the principle of having competitors get in the room and talking is something that we should be concerned about. And I think that's the reason that antitrust agencies should be paying attention to what's going on in these rooms, right? Careful attention. But there's a very big difference between monitoring, looking at what's happening, making sure that, certain boundaries are not crossed, and being very actively involved in kind of the micromanagement of this. So it's a very fine line of where do you, monitor and make sure things are going right or things are not going wrong, I should say. Maybe that's kind of what we should, versus being very active in trying to kind of micromanage and get kind of in the involvement of it. In my view, the DOJ has actually done a pretty good job at kind of finding that right balance. Especially kind of my view in the second, the second term of the Obama administration. Disclaimer, I was at the DOJ at that time, so, take that with whatever grain of salt, although I was there for about half the time, not all of it, so not completely my time. I'm not sure that the FTC, the FTC has been a little bit more active on this, so I'm not sure I would actually say the same about their policy. The one issue, though, that I think both agencies, to some extent, maybe have not taken the role of saying, there's one thing about what you do in the U.S., but there's also another issue as to what guidance you provide to the rest of the world. Right? And I know we'll talk a little bit later about kind of the IP guidelines, but I think that is a role, especially for U.S. agencies, to take on and say it's not just, okay, learn what I think by what I'm doing or not doing, okay, but maybe you should actually take a more active role to think about international agencies and how they should be thinking about this. In particular, also when you think about what the right or wrong thing to do, it's very easy to think, or not, it's easier, even in a simple world where you kind of simplify worlds and you think of a given intellectual property regime, you can think of what to do, but what do you think about a world where you're faced of a lot of different regimes? I think there was some discussion of it early on of sort of saying, you're now setting a global policy and maybe you'll be subject, I think the example was IP or patent law in Ethiopia. Okay? How do you think of kind of that world? How do you protect against it? What should you be thinking about. And this leads me to sort of a point of, I think it should be clear, but it seems to me more and more agencies, maybe less so in the U.S., but internationally, are kind of either forgetting or maybe have not really kind of bought onto this principle, is that regulation in general, and definitely not in antitrust, definitely not in this market, it's not always more is better. And then it's just a question of how can we find a way to do more? How would courts let us do more? Okay? Regulation can and does do harm. Okay, so you do have to find what is the right balance, and the right balance in terms of balancing the incentives kind of on both sides of the market, and it is something that, I'm sure we'll talk about later. And this is especially true in innovative markets where things actually seem to be working quite well. So, we talked about cell phones, I think that was mentioned earlier. Think about the cell phone industry. I mean, it really is one of the most innovative industries ever. Okay, I mean, think in any sort of economic measure in terms of prices, kind of at all levels, adoption of cell phones. I mean, is there been ever technology that's been adopted so fast? Usage? I mean, can you imagine our lives or our kids' lives without cell phones? Okay. Although you might say, well, we prefer they wouldn't have them, but let's not go there, please. Okay. But just think of how essential, what a big part it is of our world. Think of, how fast the innovation has been in cell phone in terms of speeds. Okay. And you might say, well, if there wouldn't been all these bad things happening, things would have been even faster. Really? I mean, maybe, but it's a pure scientific matter. Maybe I can't say that they would have been faster, but how much faster could they have been? Okay. On the other hand, what is the harm that regulation can do in terms of the downside? There's a huge downside, and in my view, maybe none or very little upside in terms of how much more you can improve things. Again, just think of speed that we're getting on wireless technology versus what you would get, in kind of, I know it's Philly, so we're not supposed to say bad things about Comcast, okay? But think of, the speed of Comcast, okay? How much it's improved, the speed of the Comcast or whatever internet service provider you have at home, right? How much that's improved or how little that's improved compared to the cell phone speeds that they've gone, the innovation that's gone there. So the bottom line is here, I think, any intervention should be very, should be done with a lot of caution. There's a lot of downside, and I think, just to kind of paraphrase, if you want an old piece of advice, if it ain't broke, don't fix it. Maybe we should say, if it ain't broke, don't regulate it, and stay out and kind of more as a monitoring view rather than go in. So that's the first point about the role of government. I suspect, do I have any time left, or?
Another minute?
Another minute. So let me just quickly talk about, royalty base. I'm not going to go into the detail here. There is a very simple part that sort of says, why does it even matter? Okay, if you take 10% of 100, right, if you say instead of taking the 100 as a base, I want to take 10 as a base, and you say, well, it's 100% of 10, right? There's a certain sense of just simple math doesn't really matter. It does matter because you could say, oh, you can't take 100% of a price of a product. At least, juries would never award that. So there's a little bit of a, issue there. But it's really, in some sense, for me as an economist, it's not of real substance. It's really more about the gaming, thinking towards the bargain. On the other hand, there are real issues when we think about the royalty. So let me just list them and then stop there, and we can pick up later. One is some of the real issues that there are, as already kind of discussed earlier, the licensing is not of a patent by patent base. It's really of a portfolio. And a portfolio might actually be practiced at different levels. Some of it could be at a component level. Some could be at a higher level. So it's really not do you do the licensing at a component level versus, let's say, a whole device level, but it's really do you do it at a device level, at a kind of overall the end product, or do you do it at kind of multiple levels, right? And if you do it at multiple levels, as much as a mess as we have now, and you heard some of these negotiations early on, kind of how complex they might be, it's going to get even more complicated. Because not only is there going to be more of them, it just has the incentives. Everyone has the incentive to say, no, I'm not practicing on it, this guy's practicing on it. And that guy says, no, I'm not practicing on it, this guy's practicing on it. So just the complexity and the transaction costs that are involved, are going to make a messy situation even messier. There's a few other reasons why you might actually want to go kind of at the higher product level, but let me stop here, and I'm happy to kind of elaborate more later in response to questions.
Thank you. And now, Will, and you have some slides.
I have some slides. I can do it from here if I just have a clicker.
Who's next?
Will.
That's me, WKT. So I can't really say that I'm less lazy than Aviv. I prepared only 4 slides, and I did it because I knew that unless I sat down to prepare slides, I probably wouldn't prepare for this talk at all. But just to do a little bit of level setting, can I have a show of hands of how many people are familiar with the DOJ FTC antitrust guidelines for intellectual property? Okay, maybe about half. So before I leap right into the guidelines, let me give you a little bit of background on the guidelines. The guidelines were originally issued in 1995 jointly by the Department of Justice and the Federal Trade Commission. I was at DOJ at the time, and DOJ was really taking the lead in that effort, and so I was pretty deeply involved. And it was largely in reaction to this very intuitive concept that Judge Robart enunciated in his keynote, that antitrust and intellectual property are diametrically opposed to each other in some way. And Aviv has touched on that. The guidelines was kind of built around the concept that they have the common end of promoting innovation, and they quoted a line from the Federal Circuit's opinion in Atari that said exactly that. Nobody says that the U.S. courts even, despite the creation of the Federal Circuit to try to unify the law in the patent area, nobody said that they actually have to be consistent. So you can now find many, many Federal Circuit cases since then that go back to saying these two bodies of law are in opposition and so on. But the heart of the guidelines was to kind of look behind this notion and say, okay, if you think of intellectual property not as monopoly, but rather as property, what are the implications, okay? So the guidelines set out 3 basic principles, based around that notion of patents as property rather than patents as monopoly. And the guidelines lasted from 1995 until, to borrow again from Judge Robart, the anthropomorphic notion of concepts as children. 21 years later, it reached the age of maturity, and the Justice Department thought that maybe it would be a good idea to see if they needed some tweaking, and indeed they did tweak them. And so the portion of the guidelines I'll be quoting from will be the 2017 version, which actually substantively didn't change that much. Yeah, I mean, it changed things like patent grants being 20 years from filing rather than 17 years from grant. A lot of it was technical corrections. In particular, what it didn't change was it didn't address directly standard essential patents at all. And the agencies came under some pretty heavy criticism for not taking on that issue. And so I thought it might be fun, if you'll bear with me on a bit of a speculative journey, to talk about if the IP guidelines had taken on the issue of SCPs, what would they have said? What should they have said, okay? And for that purpose, I think the starting point is Section 3.1 of the guidelines, which is titled Nature of the Concerns. And what that paragraph of the guideline says, in relevant part, is antitrust concerns may arise when a licensing arrangement harms competition among entities that would have been actual or potential competitors in a relevant market in the absence of the license, paren, entities in a horizontal relationship, close paren, okay? So there are actually quite a number of concepts packed into that one little sentence. There is harms competition. There's actual or potential competitors, and there's in a relevant market, okay? And the guidelines lump the last two together for the purpose of defining a horizontal relationship. For this afternoon's purposes, I'm going to group them somewhat differently and talk first about who would have been actual or potential competitors, and then I will talk about harming competition in a relevant market, okay? So hoping that I know which button to push. Who is in a horizontal relationship? Well, you know, think of your typical standards development organization. They've got implementers and they've got technology contributors, and some of the participants do both, and they wear two hats, if you will. Yeah, just as an aside, in general, the number of implementers greatly exceed the number of significant technology contributors. So which of these folks are in a horizontal relationship? Well, implementers, you know, pretty typically, you're going to have a lot of people using the standardized technology to create products that are going to be in competition with each other downstream in what the guidelines call goods markets. Okay? And many of them will be selling products that are substitutable for each other, and by definition, or by the guidelines definition, they will be competitors. Technology contributors, well, maybe. You know, this one's a little more complicated because the guidelines define competitor on the basis of, you know, as it says, whether there would have been actual or potential competitors in a relevant market in the absence of a license. Okay, not all technology contributions do the same thing, right? Not all contributors in the standard development organization are contributing different designs for an electrical outlet, where they all look pretty substitutable for each other. Right? And indeed, you know, if you looked at it at the back end of the process and just said, yeah, okay, what's the competitive relationship of the technology contributions that end up in the final standard, none of them are competitors, right? I mean, by definition, they are complements. You know, if they were substitutes, they wouldn't be essential. And since they are essential, they're not substitutes. So they're not competitors, you know, which is, you know, might lead you to wonder why, when we talk about antitrust problems in standard setting organizations, we always seem to be talking only about antitrust problems relating to the technology contributors. You know, a bit of a puzzle. Now, if you back up a step and say, okay, well, who's got what when the standard is being set? There are going to be different technical solutions to the same engineering problem that are potential competitors, and there are issues that are going to flow from that. Okay. I only have 4 slides, but I'm going to run out of time very quickly. So let me go on to the next slide. Goods markets, I'll touch on just very lightly. These are the same kinds of competitive issues that you find in any kind of goods markets, whether it's standardized technology or not. It's things like price fixing and market division in the products you're selling downstream. Sometimes there are vertical or raising rivals cost theories involving raising the price of an input in order to gain power over price in the output. These kinds of issues are not different in this context than in any other. And indeed, one of the points of the guidelines was that for antitrust purposes, intellectual property is like any other form of property. Okay, technology markets, this is where most of the action is. There could be issues involving the restraint of horizontal competition among implementers. They could be implementers upstream in the sense that they are buyers of technology, they're potential licensees of technology. And if they all got together and agreed, we won't pay more than X for a particular contribution or patent portfolio, that would be a buyer's cartel, right? And there would be issues to deal with there. And so, that's one of the key concerns from an antitrust point of view in standards development organizations. Then there are potential issues with respect to the technology contributors to the extent that they are in competition with each other. There are some nuances that I'd love to get into with respect to some of the so-called innovation market or R&D market cases that the agencies have brought, or at least described as innovation cases. But in the interest of time, let me move on to my last slide, which is where I think a lot of the interesting issues are. Most of the time when people talk about patent holdup and patent holdout, they have in mind a fairly simple one-shot game. And to the extent that they're focusing on restraint of competition at the technology contributor level, they are mainly talking about a patent holder that gains market power by virtue of being included in the standard and not by virtue of the value of the technology, and then ex post, after the standard is set, demands an unreasonable royalty because it is so difficult to switch out from implementing the standard if you, the implementer, have invested a lot of money in conforming to the standard. And that's fine in a one-shot game. And in the simple illustration of different forms of electrical outlets, you can see why people could argue that most of the value comes from being included in the standard rather than the value of the technology. I think when you talk about the kinds of markets that Aviv was just talking about, it's not quite so simple. And there's one technology contributor, Qualcomm, that has invested more than $47 billion in developing a wide variety of engineering solutions to some really difficult problems. If you think about why we're talking about 1 gigabit speeds these days, unimaginable even a few years ago, it's not quite like the arbitrary shape of the plug. But getting back to the repeat game scenario, how does this work exactly when you have round after round of standard setting and the licensing terms don't change from one round to another? I mean, in some sense, that is, by definition, ex ante licensing, right? I mean, because if you know that the technology contributor is going to behave unreasonably once a standard is set, then you don't include its technology in the next round. So it's very easy to see how technology contributors can be punished in a repeat game. It's a little more complicated with respect to how ill-behaving implementers can be punished through the operation of the standards development organization itself privately, as opposed to legal remedies. If we had time, or maybe in the Q&A period, we can get into some of those nuances. But I think, at least for the technology contributors, the path to private remedies and just the natural workings of the marketplace solving the problem is reasonably straightforward. So,
Thank you. And now we'll hear from Henry Wixon, Chief Counsel of Nist, and he has a set of slides. Can you just pass the remote
yes.
on? Did you want to stand up, Henry?
Very good. Well, thank you very much. I want to thank Herb, first of all, his introduction there, elevating me to the role of Chief Economist at Nist, which you'll very soon realize from my remarks has absolutely no basis in fact. I am a mere Chief Counsel at Nist, part of the Office of the General Counsel. And I want to say on behalf of my colleagues from Nist who are here today, I think we have Gordon Gilverin here with us, who's the director of the Nist Standards Coordination Office, as well as Ajit Jilavenkatesa, who is a senior policy advisor to Nist, and Pat Harris from the Standards Coordination Office. How delighted we all are to be here today to participate in this program and the work that, with respect to the work that's going on here at the University of Pennsylvania Law School to develop curricula for standards, which is so important. I think it's reflected to some extent in the discussion that we've had so far that there is an awful lot that goes on in standards development, and it's a little bit of a black box to most normal people. People who are reasonable don't get involved in it too much. But it is an interesting process. What I'd like to do today is just say a few words about Nist and the federal role in standards development, because again, it's something that most people don't spend a lot of time thinking about, and we do have a little bit of a role here. So the primary statute that governs federal participation in standards development in this country is the National Technology Transfer and Advancement Act, and then there is an OMB circular that assists agencies and provides guidance to them in doing that. And agencies also have their own specific rules and laws and regulations and policies. So in a nutshell, what the NTTAA requires of federal agencies is that they must look to the private sector for standards in order to fulfill their mission. This is a response in part to the fact that government unique standards typically aren't all that effective and don't allow agencies to realize the most economically efficient results of those agencies that are procuring products, for example, or services. And so the NTTAA created a presumption that agencies should look to the voluntary consensus standards process and the voluntary standards in order to for standards to develop to use for products that they are trying to acquire, and also to the extent that agencies incorporate the standards by reference into regulation, which is actually one of the major things that federal agencies do. It also requires agencies to consult with the private sector bodies, private standard setting bodies, and to participate in the process. And in order to keep track of agencies' compliance with these guidelines and policies, it requires agencies to report annually on their use of voluntary standards and to report on the use of government unique standards. And it permits the use of government unique standards under certain circumstances, but it is an exception fundamentally rather than the rule. And I don't want to spend too much time on A119, but it is an important circular. It establishes policies on use and development of voluntary consensus standards, and particularly on conformity assessment activities. And again, with a premise that to the extent that agencies can do so, they should look to the private sector for conformity assessment. Conformity assessment is the sort of the back end of the voluntary standards development process, or the standards development process generally. It is where one assures that the product or service one is acquiring conforms to the standards been articulated. And it's very, very important in international commerce and domestic commerce to be able to rely on that. So the goals of the legislation and the policy are to reduce costs, basically to agencies, promote efficiency and economic competition through harmonization, further reliance on the private sector to supply government needs, and enhance collaboration with the private sector on standards serving national needs. Nist has a specific role under the NTTAA as well, which is rather unique, and one of the things I didn't say about Nist is it is a non-regulatory research and development agency, so we are not a competition agency, and we don't play one on TV. But Nist has been directed under the NTTAA to coordinate the activities of other federal agencies across the federal enterprise in satisfying their obligations under the NTTAA to use voluntary consensus standards or voluntary standards to the extent that they can, and to help them to do that, help them participate, and provide assistance to agencies in coordinating their use of voluntary standards. So Nist very actively involved working with federal agencies across the government on standards development as well as on conformity assessment. So sort of just by way of introduction, one of Nist's, I think the fundamental aspect of Nist's perspective on this is that we are interested at the bottom in the health of the voluntary consensus standards process. And we need to keep in mind as we talk about things like grant licensing and all of the possibilities of a heavy hand by the government in trying to direct how that works, a couple of important aspects to that. One of which is that it's a voluntary consensus standards process. I think a lot of times regulators, including some of our competition regulator colleagues, lose sight of the fact that voluntary consensus standards developers, SSOs and others, standards developing organizations and standard setting organizations, cannot compel their members to do anything that their members don't want to do. And lots of times when you get involved in a conversation like the one we're having today, where you're talking about competition law, you will hear colleagues of mine say, oh, well, the standard setting organization should obligate so-and-so to do such and such. If it gets too onerous, members can walk, and we have seen that recently, that they can do that. And so that's an important thing to keep in mind when we talk about imposing obligations on standard setting organizations, that they are at the bottom not able to actually force anyone to do anything. It's a voluntary system, and folks can choose to go to other models. The other point I want to make in particular is that we are today talking, as almost invariably we do, about the telecom industry, right? Why are we talking about them? Aviv mentioned why. It's real important to all of us to have a smartphone, and there's a hell of a lot of money at stake. The point I want to make on behalf of NIST, and I also want to say that I'm not speaking for NIST or the government, just speaking up here as myself, is that there's a huge universe of standard setting that goes on in this country and around the world that has nothing to do with telecom, and that in fact, despite the amount of money that is involved, telecom standards are a relatively small fraction of the standard setting that goes on day to day in this nation, and fundamentally without controversy. The system overall works very well. And so we must keep in mind as we talk about trying to impose on standard setting organizations obligations to do it this way or that way or the other way, the fact that there may be unintended consequences on the vast majority of the standard setting work that goes on in this country that we're just not thinking about, and it's not part of the conversation. And so, you know, one of the points that I guess I'll go on to the last slide. One of the other aspects that actually I think of as one of the strengths of the voluntary consensus standard setting here is that in response to some of the suggestions that have been made by some of our competition law agencies, SSOs have reacted to that. You know, what are they supposed to do? And we have a federated system, and we have the ability, and this echoes to some extent the comments that were made earlier, we have the ability for different standard setting organizations to try different ways to address some of the concerns that are expressed, and they are interested in doing that. And it's possible that we will have different solutions by different standard setting organizations. We've seen some controversial ones. IEEE is the one that we talk about most of the time. And some of these approaches will work and some of them will not work, and that's fine. We have a system that is strong enough to allow that. It's allowed different organizations to try different solutions. And so in that respect, to the extent that we think that we should here talk about a one-size-fits-all solution for standard setting to address a particular problem in a particular distinct industry sector, we need to be very thoughtful before we take those kinds of steps. And we also need to consider whether, in fact, there is if we're talking in the antitrust context, whether in fact we actually have a distortion of competition that would justify taking such a step. Our system is, as I say, I've said it over and over again, it's a voluntary system. It is relatively unique in the world. Yet we believe that it achieves the best results and the best technical standards because it is an industry-led system. And so that is fundamentally the way we do it. Other countries, other regions of the world have top-down government-led standards, which I think we generally, certainly Nist thinks, are a less effective way of achieving the best standard to come up with the best solution to a technical problem. And so we must keep in mind as we think about these things that the health of the overarching system is of importance, is worth considering. And so we should be circumspect. And with that, I will end my remarks, and thank you very much.
Thank you. And finally, Kirti Gupta, you understand?
I think so, because I'll be able to drive easier. Thanks to all the organizers. This has been a real pleasure to listen to everybody today. And I thought, what can I add to this, excellent panel of very well-known lawyers and economists? I'm an economist myself, but before that, I was born and raised in the telecom industry as an engineer, as a wireless systems R&D engineer. So I thought I can speak a little bit about the wireless cellular industry. And especially because, as we've heard from Henry and we've heard from our friend from Microsoft in the earlier panel, there are a lot of standards that are about interoperability, where common language is key. I think we heard the example of a two-prong versus a three-prong plug. Heck, there are standards also for pencils. I didn't know that until recently. So there are thousands of standards. But I think the dimension that I'm most familiar with is really a different dimension on the one hand, the standard setting organizations where it's mostly about interoperability. On the other hand, what I'm familiar with is standards development organizations where it's less about the interoperability and common language, although that's key. It's really about setting new technologies, creating new solutions for problems that are fundamentally brand new, for which solutions don't exist. So that's what I'm most familiar with, and that tends to be usually the focus. Wireless cellular standards usually tend to be the focus of conversations around standards and standard essential patents, and why not? They are the most commercially successful, as Aviv and Henry have alluded to. So I thought I'll start with a chart of a world map, right? This is the world map of the population of the world as it stood in 2016 and subscribers. And you can see that in most regions and in total, there are more mobile subscribers today than people in the world. And that's growing really fast. And it's just to say that any policies we think about for IP or for antitrust has not only implications in the United States, but in the rest of the world as well. So our tone matters, to Aviv's point earlier. So wireless standards, why have they been so enormously successful? It's, I just wanted to walk you through the technology behind the generations that we all use and know and love. 1G, 2G, 3G, 4G, 5G. I'm sure you've heard the monikers before, but I just want to impress a couple of things that I've learned as an engineer and I think are relevant in the policy and a legal economic type of dialogue. Wireless cellular communications, or these wireless technologies that are at the center of the standards dialogue, are about solving a really fundamental technical problem. And it's this: there is only this much finite amount of a very, very expensive and scarce resource in the world called radio frequency spectrum. And it's about how much and how fast and how reliably you can transmit information over this extremely expensive and scarce resource. That was the Shannon's capacity limit theorem set by Shannon, the father of digital communications, in 1948, and that's what engineers have been trying to solve in all of these generations, which have excruciatingly developed a decade at a time, incrementally, one on top of another. You might remember that time when you were using your brick phone or your phone in your car that was 1G, analog communications, not digital, and then 2G made voice and texting commoditized, remember that? And from 3G, we all started using our emails and we started browsing the internet because data speeds were becoming faster. And with 4G, video streaming is everybody's new toy, right? And 5G is not even about connecting people anymore, it's about connecting things with each other. So every generation, the two things I wanted to underline are, every generation took at least a decade of R&D before it became potentially commercialized or potentially successful. And Albert gave us a perfect example of that earlier in the day. We've all used 4G, we've all heard of LTE, but few people have heard of WiMAX, 4G standard that wasn't that successful, and fewer still of UMB. So this is a risky endeavor. And the second thing is that this is an incremental process. Reputation, repeat play, these types of things matter. And just one more thing I wanted to add here is that the importance of doing this risky R&D well in advance also tells us how important balancing the incentives are between different types of implementers and inventors. And why does it matter to us now? Because obviously when we are working as an industry on 5G, we have to recognize that this is, and continues to be an R&D heavy industry. So I thought I'll pull some numbers out for you because, they tell the real story. And if we look across industries, mobile tends to be the second most R&D intensive industry across the ones that are familiar to us, biotech, pharma, for example. And not only that, there are few companies that serve as the R&D arm of this industry. So this is an example of the wireless industry's distribution chain that on the one hand shows those types of companies that are innovating in the technology space. On the middle are the product-centric companies that are manufacturers, and on the right-hand side are network operators that are the service providers. And you see that everybody invests in R&D and capital expenditures, but because one part of the industry tends to be more capital R&D intensive, it enables others to invest in other things like being more capital intensive. And I studied the data for companies that came to 3G and 4G and are coming now to 5G standards and are participating in the creation of those standards. We have around 500 or 600 companies at any given time participating in the creation of these standards. And the data shows you that the distribution of contributions is extremely skewed, right? 9 top firms out of these 500 are responsible for around 60% of the technical contributions, the small, little technology solutions that add to the larger whole for creating these standards. And around 20 are responsible for 80% of these contributions. This is just to explain and demonstrate why these debates sometimes tend to be really polarized because the nature of the industry is extremely R&D intensive, and few companies have to serve as an R&D arm of the industry because it's upfront 10, 15 years in advance, risky R&D, and the whole ecosystem has to build on top of it. Just because we've talked about the licensing related issues, and I know we are going to continue, one more thing about these technologies, I've been in the trenches in the standards bodies. The technologies tend to be, because this is about optimizing the use of that really expensive and really fundamentally limited resource, they tend to be system-level technologies. My phone can't talk to the network just by some component or a chip in the phone. It has to process that signal. It has to send the signal across to a base station. The base stations have to talk to each other, or the antennae. They have to talk to the servers. The servers have to talk to each other. They traverse the entire system. And let me give you just one example. So one of the main new technologies in 4G was MIMO, different antennae, multiple input, multiple output, different antennae packed on a cell phone altogether. That itself is a miracle of a problem because they all tend to, when they send signals to each other, they tend to interfere with each other. So how do you pack a lot of antennae together to be able to form a beam and send it across to the base station? you see, if you even open patents and read their claims, they are claims that read on different parts of the system. How does the phone do it, and how does the base station do it, the antenna do it, and how does the server handle these signals? And therefore, the industry, because of this problem, by the way, one paper that studied a sample of a large representative SEP portfolio from Ericsson, Jonathan Putnam and Tim Williams, showed that around 80% of the patents read on different parts of the system, different parts of the network. But to that point, that's why the industry sort of reached this equilibrium of licensing large portfolios of these patents at one single point in the value chain, because if we were to go down the path of licensing, breaking down the portfolio, we would be licensing at different levels in the value chain, multi-level licensing, which will usually increase the transaction costs for the industry. And going back to why does any of this matter, I think Henry alluded to it really well, that if the policies in place aren't policies that are balanced for all sorts of incentives, for all sorts of business models, we are going to see shift from the standards, collaborative standards type development of new technologies to different types of business models like proprietary or de facto standards. And for what's at stake, it's something really important. It's 5G, the next frontier of mobile technology, which requires completely new solutions that we haven't really addressed in 1G to 4G yet. And I just give some examples here, but you can all imagine what they are. Automotives to smart homes to smart cities. They tend to be requirements that are very different from each other. On the one hand, I have to be able to allow very, very fast data access. And on the other hand, if your sensor trips, then your signal, even if it's a short, bursty, one-time signal, it has to go and make its way to the destination point really, really fast, really, really quickly. Very different types of requirements need to fit in 5G. So that's just some examples that I hope can facilitate our further discussion today. Thanks.
Okay, that was great. We've got about 20 minutes left. I'm inclined to open it to questions unless a panelist has a comment to add, response to anyone? Nothing? Good. Okay, any questions? Yes, Mike.
There's a lot of focus the last few years on standard essential patents, on antitrust law. From your perspective, has the operation of standards organizations changed as a result of this focus?
Anybody?
I can give one example from the IEEE standards. I think we heard that there was a recent policy change in 2015, and now we are sitting 3 years, after that policy change in IEEE SA, and it was a controversial change. And the one thing we have seen from the data is there was, the patent owners give assurances in IEEE called the letter of assurances to declare that they will be licensing under, the FRAND commitments of the IPR policy. There's been a significant uncertainty that has been raised in IEEE since that policy change. In fact, most of the letter of assurances that have been submitted since that policy change have been negative letter of assurances. It's unprecedented that licensors submitted letters saying that they will not be licensing under these new policy terms. And since, actually, 86% of the LOAs received since that policy change have been negative once you repeat and duplicates. And there are 2 standards that have already been approved by IEEE under this mixed bag of LOAs. So it's not clear what's going to happen, and it provides a lot of uncertainty in the system.
I could just sort of add to that. In some respects, what we've seen over the last 5 to 6 years is we've seen standard-setting organizations react to some of the pronouncements that have come down from some of the competition agencies, both here and in Europe. And one of the things that has done as standard-setting organizations have tried to address some of the concerns that have been expressed, they are implementing changes, and IEEE is an example of it, where the consequence of that is that it affects licensing negotiations between, later on, when someone has made a letter of assurance and is then in the process of licensing. Some of these changes affect business models, right? So you have different, and we've heard some of that earlier in the day. You have different companies involved, they have different business models that drive their approach to the entire process. And as we try to define the rules for standard setting organizations in one particular way, and it doesn't really matter which way, we affect the business models of organizations which heretofore have been able to work it out amongst themselves. And so that's something we need to be cognizant of as we do that, and we need to be cognizant of it in both directions, right? So we had this hold-up discussion, and people asked, some people said, well, what is the hold-up problem? Is it really there? Is there actually evidence for it? And now we are hearing suggestions that we're going to focus now on hold-out, right? Which maybe that's good, maybe it's not, but if we start making those, standard setting organization is going to be then in another 2-3 years reacting to that, and we're going to whipsaw them back and forth between trying to accommodate what at its base is one business model versus another business model, and is that what we should be doing as regulators? Where there's, in the absence of a failure, in the absence of predatory behavior, what define predatory behavior.
I'm not sure that moderator is allowed to answer a question, but I think I'm going to take a shot at it anyway. To me, it's been quite remarkable how little antitrust, that is actual antitrust litigation, how small a role it has had to play in this process. Everybody mentions price fixing. Of course, if we ever found it here, that would be a problem. Unilateral pricing is not, under U.S. law, really an antitrust issue. The firm acting unilaterally can set the price it wants. Unilateral refusals to deal, refusals to license are not an antitrust issue. In fact, 271 of the Patent Act expressly permits firms to refuse to license. So if that's got to be addressed, it's got to be addressed through the basically contract or quasi-contractual system that the standard setting process contemplates, with perhaps some additional doctrine like equitable estoppel or something like that. The one place I can see for some antitrust liability, and Kirti might want to object because it involves Qualcomm, and that is there are some allegations in recent litigation involving Qualcomm about tying and exclusive dealing with respect to standard essential patents. That is to say, a firm refuses to license a standard essential patent unless the licensee agrees to purchase a product from that firm, or unless the licensee agrees to deal in that company's firms exclusively. And those fall within the traditional concern of antitrust law. I'm not saying they're illegal or they're illegal. They are market power offenses. Market power would need to be established, and there's currently a division among a couple of European courts about whether the fact of standard essentiality is enough to establish market power. I don't want to resolve any of those issues, but just to note that there is a small amount of room for antitrust, but it's, I think, going to be limited to a small number of practices that fall within the general traditional set of antitrust rules that we already have. Anybody? Good, okay. Anyone else? Yes?
Well, that one's for you, I think.
It looks like you've stumped the panel.
So flesh out a little bit what you mean. Give me a hypothetical. How right? Mm-hmm.
So as the very long as we're thinking about whether we can how we utilize the licenses, start to add up because of the ticket of patents that we start running into this issue of what will the price of the product be? Vis-a-vis the price of the license, the cost of the license. And what will that do in terms of technology? The technology that are on the side. What will actually companies decide to spend much more money and bring that back to the technology here to a standards essential patent space.
Mm-hmm.
And also in general, when people say this is getting way technology that are using very well to be able to have access to this technology because this technology is moving so fast.
So I guess my reaction to that is you're really not talking about fundamentally different problems from what the cellular communications industry, for example, has already faced. And as Aviv said, they've done remarkably, incredibly well in surmounting those problems. So if you look at the slide that Kirti put up, there's probably never been an industry in history that has innovated as fast and has progressed as quickly under a model where the problems that you're describing of potential royalty stacking and so on are largely dealt with by the fact that these are repeat games, and these are people who will have to deal with each other in round after round of standard setting. And if a technology contributor misbehaves, it will eventually get punished. The worry that I have, that I think is also implicit in your question, is what happens if the government regulators get it wrong, as Aviv hypothesized, and as Henry said, people, as a result, start walking away because you can't get an adequate return on the amount of innovation that Kirti described by participating in a standard-setting organization, right? Because there are lots of different kinds of innovation. There are companies, and I mean, I hate to keep mentioning Qualcomm, but there are companies like Qualcomm that are really, really good at system-wide innovations that they do very little implementation, right? They make most of their money by licensing system-wide innovations that are used by network operators, by cell phone manufacturers, by manufacturers of components that go into those cell phones, right? If you can't get an adequate return through licensing, and this is one of the points that the IP guidelines made, right? Why is licensing pro-competitive? Because it enables complementers to work together. If you can't do that and get a full return on your R&D, you're going to invest in R&D that is less socially valuable, but that you can appropriate more of, right? So if you can appropriate more of a flashy appearance for your product that you are selling than you can by increasing the speed of a network by an order of magnitude, then you'll invest in making, fancier cases for your device. Is society going to be better off as a result? I don't think so.
Let me just jump in, I think one thing, if you go back to go to old classical economics, there's very hard problems of just setting, if you think of how do we set all the prices in the economy, basically, it's a very hard problem if you actually sat down and said, I want to solve it as a social planner. And you could take very smart people with a lot of computing power They won't be able to actually do that. And unlimited data even won't be able to do that. But somehow the market figures that out. Okay? I mean, does it figure out perfectly? Probably not. But for the most part, the market works. And I think that should be the premise. And I think we should bring that same premise here in the sense of, you know, will it be FRAND? Will it be something else? I'm not sure. I can tell you actually a funny story about looking into kind of our future predictions. In 1998, I had a good friend of mine. I was living in Berkeley. I had a good friend of mine I had for a barbecue. And he just finished his MBA at INSEAD and had a startup. And I asked him, you know, well, what do you do? And he said, I create value added in the cellular phone industry. I looked at him and said, enough with that MBA crap. What do you actually do? He says, well, and this is 1988. Remember, we had the little, you know, screens about, you know, the size of, you know, your watch. I create games for the cellular phone industry. I looked at him and said, what are you, nuts? Who in their right mind would, A, want to own a cell phone and play on it? Okay? He sold his startup about a year later for only $1 million. He should have hung on, maybe would have made a lot more. But it just shows you a little bit of our ability to predict these things. So, you know, 15 years in the future, who knows what it would be. But I think the key is we want to let the market, work. And I think as regulators, you know, we should kind of make sure that things don't go too much out of bounds in either direction. But I don't think that we should actually try to sort of say we can pick the winners and losers because we can't. Okay, just like I failed miserably in 1998, if you ask me to do it again, I will fail miserably again. So I'm going to refuse to do it. And I think, you know, that's what we should do. We should let the market work within bounds. Obviously not get, you know, things out of extreme, but that's, I think, what should be the role. Rather than trying to say, do I know this will work or that will work? I don't know. But the market's going to figure it out.
Still have room for another question or two. Yes, in the back.
So I think I would take issue with your reading of Lexmark. Lexmark, it seemed to me, was based on the notion of not wanting these hidden property rights to go riding along in the stream of commerce and springing out and catching unsuspecting downstream users, right? And so, you know, the analogy that the court used was, you know, you go into an auto repair shop and you know, the repair part goes into your car. You should not have to you know, worry about whether there are intellectual property rights in there for which, you know, you might be sued. But I think the court was very clear that for the parties that are directly in privity, you can enforce the license as a contract right. And it did not try to limit how you can enforce that contract right. It said you've got no patent right once you sell the product. But if your contract with the initial licensee is that you're going to pay me X% of the price of the product that uses this component, there's nothing in that opinion, I think, that stops you from doing that. So I think you need to separate the notion of how you calculate a royalty base or the compensation between the intellectual property owner and the licensee from whether the patent is exhausted by the sale. And just to add one more hypothetical. I love hypotheticals because it just, examples make things clearer for me. So, suppose you've got an innovation that makes a cellular system work 10 times as fast. And you can see, the cell phone before that innovation sold for $200, and the cell phone, in the new system after the innovation, sells for $800, right? Suppose, and this doesn't happen to be, as Kirti showed, that's not actually how the patent rights work, but suppose that the patent can be entirely practiced in the component that goes into the phone. And the component is, if you're not paying royalties to the patent owner on the component, you can sell this component for 10 cents. Should 10 cents be the cap on the technological innovation that contributes $600 worth of value, social value to the world? I don't think so. Oh, yeah. I mean, certainly as a theoretical matter. I think as a there are two practical answers to that. One is that as a practical matter, the people who argue SSPPU are usually arguing it as a defense and claiming that they can't be charged more than, X% of 10 cents for patent infringement. Okay. And I think the second and more important practical answer is the one that Aviv and Kirti talked about earlier in the panel, is that most of these times the innovation is not entirely practiced in the component. You're talking about system level patents, and if you prevented this device level licensing, the result will be multi-level licensing, not component level licensing. And then you would have the device maker saying, oh no, the component manufacturer should be paying. And the component manufacturer will say, oh no, the device maker will be saying. And all of, not all, a huge proportion of the social value of this innovation will be sucked up by all the transaction costs and rent seeking and so on. So it's not a very practical solution given what most technological innovations are like. But I agree with you. In theory, if it were all in the component and you price the component in a way that reflected all of the patents being practiced by it, yeah, sure. I mean, it's like Aviv said, a different percentage of a different royalty base could mathematically yield you the same result. But given the practical concerns, what's wrong with what we got?
Okay, with that, I think we are finished. Like a hand for the panel. Thank you.